This is the matter of the Republic. It has no case number versus Edwin Kiama. I and my colleague Harun. I'm Martha Karua, SC, and with my colleague Harun, we are here for Edwin Kiama, who is the respondents. Kenya National Commission on Human Rights, the national body, are also here. Who is here for them? Mr. Kam? Miss? Okay. Watching brief. So, Your Honor, this matter has not yet been registered. Mr. Kiama was brought here early morning. We as his councils have been here since 10. It's now since 9 for Mr. Ndumbi and for me since 10. It's now going to 1. It is not fair that we be asked to wait any longer, whether 10 minutes. And this being a bailable offense, we are urging you, even without a file, to admit Mr. Kiama to bail, to give us a time tomorrow to come. It will give the officer investigating enough time. And I know Your Honor might think that it is okay to give them a few minutes. They arrested Mr. Kiama yesterday in his house. They therefore know where he lives. He is not a flight risk. This is a bailable offense. We're therefore asking you to admit him to free bond and give us a time tomorrow or even Friday to give the investigating officer enough time. This application, I know he would like to detain him for 14 days, which is laughable. Because if you arrest somebody, you arrest them when you have enough information. They already have his computers. From the information he has given us, they have taken his gadgets. So whatever cybercrime they want to charge him with, they already have the evidence with them. We are urging you to release him on bail, to admit him to bail, and to order him to come before you on Friday or even Monday. It gives them enough time to do whatever it is that they wish to do, and then we can come back and take the plea. And I would like to say that the police and the law enforcement agencies should never be allowed by a court of law to punish suspects.
I don't just interrupt. I think I cancelled because this is a court of record, and I just sought for directions. So
no, we also have a right to make our application.
Yes, but the file is not properly for it. So that we also do things procedural.
It is procedural to bring a suspect to court while not being ready. Hold both him and the council's ransom. We've been treated as though we are abused persons. We've been here the whole morning. So I do not understand what my colleague is talking about, and I would like Your Honor to know that under which you already know, under the Cyber Crimes Act, they're supposed to have a warrant when going to search somebody's house. He's already broken the law. He's now inviting you to detain Mr. Mutemi for a further 14 days. And I think the court should be shown the affidavit, yes, ours, to admit him to bail. And you need to treat both the Republic, who are the complainants, and the Mr. Mutemi, who is the respondent, equally. The law demands that we be treated equally. The Republic is behaving as though the Constitution does not exist. These are not the days when the Republic came to court with heavy boots, seeking to get favors or privilege more than the other people. We are saying they came, they are not ready. We would want to be released to go home together with the respondent, and we can come back to court. Because I don't have the file in front of me.
I cannot admit bond. For you, the processes of admission of bond is that I must have a number, or you must have a number for your client. The money is paid to KCB with a number, which we do not have. So my hands are tied, even if I have the authority to give bond, because I cannot receive the money and take it to my office. It must go to an account. So we must get this number. The delay caused by the prosecution is maybe it should be telling us, is it the internet that is a delay? Is there someone in the office who is delaying? That is what they're supposed to tell us. It is the police who are holding, because this is just an office. The police have it. So the police should be releasing it. The court cannot be releasing someone who is not before it. Somebody comes before me through a file. So I don't have this person here. So I'm not able to release someone who is not in court, for lack of better words. So unless I get a court file with details admitted in our systems, I cannot deal with it.
May I, with respect, refer you to Article 159(2) of the Constitution, which says that justice must not be sacrificed at the altar of technicalities. Procedural issues about files and numbers, those are technicalities. It is not his fault. Your oppression on the part of the respondent, and even on the part of councils. We've been here the whole morning. There was no courtesy to come and say, if they are councils, could you go and come back in the afternoon? They take it as though they have the right to detain everybody. I am urging you have the jurisdiction. You actually can record while you wait for the number and admit him to bail. And we are not suggesting cash bail. For a person whose house they know and visited, we are asking you to admit him to free bond. So the issue of KCB will not arise. Admit him to a free bond, and we as council undertake to bring him to court on the day you will have prescribed. I'm urging you, you have the jurisdiction under the Criminal Procedure Code, under the Constitution, which is superior, and you have to set the record straight that the police and the state law office have no authority under the law to bring a person to court, fail to register their case, and expect that the court will walk out on that person to be returned to custody again. We urge you to admit him to bail and order his return, whether tomorrow, because this afternoon will be oppressive to us. We have other matters, so that we go. He also can go and take a shower, having slept in custody. The police already were able to punish him without a court order last night. And then we can come back and hear the plea. There's nothing wrong with that, Your Honor.